Hello and welcome to Telesur. I'm Carla Gonzalez. This is Interviews from Quito, the program where we explore some of the biggest challenges facing this country and the region. In today's program, we look at how Ecuador could make history if it passes a law to allow same-sex marriage. Currently, in a mainly Catholic country like Ecuador, marriage is only allowed between a man and a woman. So will Ecuador stay true to its respect for human rights and equality and give way for a decades-long fight? We have lawyer Bernarda Freire to discuss this. But first, let's take a look at this video.
The Constitutional Court of Ecuador has called a hearing to rule on same-sex marriage. The petition was submitted by an LGBTI couple after the Ecuadorian Civil Registry Office did not recognize the marriage between persons of the same sex. The legal team of the LGBTI couple say that if the court approves the legal consultation on same-sex marriage, all sexually diverse couples will be able to marry, and that will be a historic step in Ecuador. Meanwhile, several organizations in favor and against equal civil marriage gathered outside the Constitutional Court. LGBTI groups say they are hoping the members of the court will be more sensitive to their struggle and guarantee the recognition of LGBTI rights on same-sex marriage. They point out that Ecuador is a country where the Constitution prohibits discrimination.
So thank you, Bernarda, for being with us. First, let us know the organization that you work for. What do they do?
I work in Foundation Pacta that has been working for around 12 years and was born after the need of LGBTI to have access to a lawyer with knowledge on gender and structural discrimination of our population and how this discrimination affects legal processes. It is composed by 6 lawyers who are basically a cost-free law firm that receives cases, provides advising, and if necessary, we also sponsor clients in cases of sexual discrimination.
The law itself, because a lot of people, when they talk about same-sex marriage, they don't know what the actual law says in Ecuador. What does it say?
The LGBTI population has suffered discrimination, structural discrimination, as I said, and we have had many progress and positive things in Ecuador in the last 20 years. 20 years ago, homosexuality was still criminalized. There was still a jail for a homosexual population. After this was overcome in 1997, we started making significant progress regarding sexual orientation. The first was the 1998 Constitution that acknowledges that no one can be discriminated based on sexual orientation. Then came other changes, and the 2008 Constitution provides not only sexual orientation but gender identity, and establishes that families can be recognized in different types according to Article 66. But LGBTI population has a constitutional law to get married. Article 68 says that marriage is the union between man and woman, etc. And this has prevented LGBTI population from marrying. Nevertheless, other progress has been made, not legal but jurisprudential, in the Latin American context that enables us to understand that marriage is recognized in Ecuador. The first we must understand is that the Constitution cannot be read literally, but must be read within the context. The Ecuadorian Constitution says that we are in a country of rights and justice. This means that rights and people are above rules. We must also understand that Ecuador executed the American Convention of Human Rights, which has an entity that rules the convention and how the states must enforce the convention, which is the Inter-American Court of Human Rights, that has consultative competence when a country makes a consultation. Costa Rica made a consultation in 2017 about the LGBTI population, especially trans childhood and protection for couples of same sex. the court explains that the states of the Americas must recognize all existent figures, including cyber marriage, to diverse sexuality couples. In the world now, couples in Ecuador are asking the Constitutional Court to enforce consultative opinion 2417 of the court, and that interpret an article in the Constitution in virtue of this consultation and the hermeneutical rules of law. Basically, evaluative methods. The law has to go together with social changes, not only by the rule. We must understand the Constitution as a live tree, as a full body, through the principle of equality, non-discrimination, the protection of all kinds of families, and in virtue of the pro homini principle, what is the most favorable for couples of sexual diversity, to marry and not to marry. This analysis is contained in the consultative opinion, and what we are asking as LGBTI is to be acknowledged the right to marriage, that it be materialized through the interpretation of the Constitutional Court.
So, what do you think are the main challenges to this, the application of this same-sex marriage law in Ecuador? Maybe it's conservative groups, religious groups in Ecuador?
Yeah,
as I said, the LGBTI population has made great steps. Perhaps the society hasn't had time to understand these changes. We must understand that the context of the Ecuadorian state is social context that is run by machism, discrimination, xenophobia. When we listen the arguments against same-sex couples from marrying, these arguments are basically opinions, beliefs based on religious topics, and of course, they try to make them legal somehow, saying that the Constitution says that Article 68 says that marriage is between man and woman, and that is their strong argument. But as I said, Ecuador is a country that is formed by the rights and justice. And rights is the most important, and consultative opinion establishes that LGBTI population has been discriminated on several occasions in these years. The Inter-American Court even numbers the times LGBTI population has been discriminated with the intervention of the court. It did it Atala versus Chile, Duque versus and Romero versus Ecuador. Ecuador already lost one case before the court in virtue of a person's sexual orientation who was discriminated. So what we have to understand is that if we do not allow same-sex marriage because of religious concepts, we are remaining the past century as a state. This is the time when the Constitutional Court must say we will enforce the rights of the people above the opinion of the others. Many arguments say we have to make a consultation because the Constitution has to be amended. This is a violation against democracy. We cannot subject the rights of majority and the votes of majority. This is against democracy and against the rights of people. We cannot ask if we exercise or not a right, because it is our rights which are at dispute. And the court must say we will interpret regardless of religious opinions, because the hearing that was held on Friday, a consultation hearing, there were 40 amicus. Amicus are opinions of civil society to the judge, for the judge to have better elements. Anybody can present an amicus. There were 40. Among these amicus, around 35 were in favor and a few against. And all these were cross-cut specifically by structural discrimination we are living as LGBTI population.
Can you explain why this court hearing happened, how the case came before that, the whole context, to understand a bit more?
The struggle of egalitarian equity started in 2013 with the case of Pamela Troya and Gabriela Correa. The protection action was filed. There were several legal impediments, and finally a negative sentence was issued. It went up to provincial court and then to the Constitutional Court in a special protection action. The years passed, 5 years have elapsed since we arrived to Constitutional Court with the first case, and the former court did not have the political will to address the case. They didn't receive the case, and the case was frozen there. After the consultative opinion of 2017 arrived, the Ecuadorian state was notified, as all states, with this interpretation of the highest organ on a specific topic. And LGBTI populations were very excited for the arrival of this consultative opinion. We started legal proceedings. 10 legal proceedings were filed by 10 couples to be recognized marriage. 2 were made in Cuenca, 1 in Guayaquil, and other 7 here in Quito. 2 of these actions were filed by the collective jurist feminist and my foundation. The others were my foundation. We started actions and we won some, 3 or 4. We lost others. We continued in the second instance in provincial court, and the specific case of Efrain Soria and his couple, we reached provincial court, and the provincial court, in a correct exercise, said, okay, here there's an antinomy, a contradiction, and as a provincial court, I do not know how to interpret Article 67 of the Constitution, so I will ask the highest entity of this country. And according to the criminal rule, the case of Efrain Soria asked the Constitutional Court what it has to enforce, the Constitution or the Constitution and the American Convention with the consultative opinion. This went to Constitutional Court, and in parallel there's a change of the judges of the Constitutional Court. Procedures were established, and in a consultation hearing, we must remember that the part that is consulting is not us, it's not LGBTI, it is the second hall of criminal matters in the case of Efrain Soria. And a hearing was held where all people who were interested or had the intentions to establish arguments against or in favor of the interpretation of Article 67 of the Constitution were listened by the Constitutional Court.
You've been part of a lot of these legal processes, and we've seen how difficult and how sometimes discriminatory the whole process is if one is from an LGBTI community and wants to get married in Ecuador. Can you walk us through all the steps that need to be taken?
Yes, as a Pacta Foundation, that is an organization that started in 2016 at the end. But as an activist, I was part of the process, even of Pamela Troya since 2013, and Jorge Fernandez, who is also here in the foundation, is also part of this process. As an activist, as an individual and human being, it's very complex to listen arguments that are offensive. In this marriage process, the Ecuadorian state has violated us as a population. Several hearings, we have listened many things that are not legal arguments, do not have juridical level to discuss, and have been very offensive. For example, in the hearing in the couple in Guayaquil, as an example, we attended that hearing in Guayaquil, and during the hearing, the general attorney of the state said, you will never be a family. You will never, regardless of if you marry or not, you will never be a family. The result of this specific hearing was, of course, counselors, Jorge and myself, we were very affected by this, and the couple as well. They almost stepped back in the process. They almost said, I do not want to continue, and placed my family in question, because regardless of what happens with marriage at this moment, couples will continue living together, will continue caring for each other and complying with all these things that are socially understood as marriage. It was very difficult for the couple, and the four of us were crying at the end of that hearing, the two counselors and the couple. This is an example of things that can happen that affect the couple, but also affect the attorneys that are part of sexual diversity, those of us who are working there and are doing this as a commitment of life. In the amicus curiae that was submitted by Pamela Troya to the Constitutional Court, in her participation she mentioned that throughout these years of struggle she has received very offensive comments in social networks regarding her way of being, her work, her life, weight, her physical appearance, and this is very offensive. When you give an interview or you are in social networks, you have some favorable comments, of course, but others are very, very painful. There's people who make chains of praying to save our souls and stuff like that. But all this is compensated, of course, when at the end of the process we have couples that can materialize their right to marriage. Beyond being a right as such is also the way in which the state acknowledges LGBTI population as a family. This is the most important. The struggle for marriage gives place to people's understanding that we are family, that we must be protected as a family, and also for the state to allow educating population better. And this will gradually delete the gap of structural.
So if today a same-sex couple comes to you and says, we want to get married, we know we are going to be denied because the Ecuadorian courts are not allowing it at the moment or are finding a way to block it, can you walk us through what different steps they have to take in order to fight the system that doesn't allow them to get married?
In this context, at this time, they would have to take an application to Vital Records, a written one, and this should be denied, because this is what Vital Records does. It refuses because they don't allow same-sex marriage. With this refusal, a protection action, a jurisdictional guarantee starts, which is also called emergent. Takes a short time. You file the application, a demand, and it notifies Vital Records, and a hearing takes place in the next 48 hours. The sentence is issued, we think is negative, and with that we have to appeal to the next instance, which is the provincial court. We would understand that in a common case of a violation to a constitutional right, the sentence in second instance should take no longer than 1 month. Nevertheless, in our cases, we have taken around 1 year in all cases. And then comes the provincial court sentence. We would start a new action, a special protection act, before the Constitutional Court. At this time, we have 6 couples that have filed a special action in the Constitutional Court, which is not the same as a hearing that is not performed by us, but the second criminal court, while the next hearings will deal with special protection actions of other couples.
Seems to be very long and very expensive. Do you cover those parts as well?
As an organization, we don't charge any user in any case related to discrimination. As an organization, we qualify the case, and in case of discrimination, violation of rights, victims of hatred or discrimination, we don't charge. Of course, we qualify cases because as an organization, we don't receive funds from any place, from the state, any other organization. We are self-supporting ourselves as attorneys, paying ourselves a monthly fee, and we don't have much time or worker, so we qualify most urgent or emergent cases. Otherwise, we also go with ombudsman, with public defensory. But in the specific case of marriage, even if the process is long, it has no cost for the couples. I expect that in the next 45 days, marriage become a reality, a materialized reality in Ecuador. There is no legal way that does not take to marriage. If you make a legal analysis of any part, from any angle you may see, we will reach marriage. If not today, it will take place in 1 year. Otherwise, back the organization and the couples we're working for, we are willing to reach the Inter-American Human Rights Court.
And based on some of the figures that you have, how many of the couples that come to you, to PACTA, to the foundation, actually go through? Because if someone tells a person that it's going to take them a year to finally see if they can get married or not, it's going to be a very tough road to take on.
The couples with which we are working, 8, are couples that are living together for a long time, 13, 14 years, 12 years together. Regardless of what happens in the process, they will continue together. While the process is very tedious, it has peaks at certain times. In the case of Efrain, for example, I had a hearing, for example, that was a terrible emotional peak for the couple, and then there were 5 months without any results. That also causes anguish and concern, and then peaks again. So we have discussed with the couples. When we started the process with our couples, we explained clearly that this is a complex process, that we don't know what was going to happen. We would never imagined we would have reached a constitutional court with a consultation. We always imagined that we would accumulate causes with all the couples. But things have taken place differently. We explained to all couples that we have kept absolute confidentiality of the couples. Nevertheless, there was always the risk that this come to light at a given time, and that any couple, in this case Efrain, reach constitutional court and this become known. All the couples agreed in this and committed with us in continuing the process the time it is necessary, and I am sure that our peers of PACTA Foundation and the couples who are working with us will reach together to whatever is necessary to materialize their right to marriage. Now, I truly trust and I believe in this constitutional court because it is the best academically formed court in all these years, and I am sure that in 45 years, marriage will be materialized.
Thank you very much, Bernarda, for your time. So we've been talking to lawyer Bernarda Freire on the possibility that Ecuador approves same-sex marriage, which could end with years of discrimination for the LGBTI community in the country. Thank you for watching. This is Interviews from Quito. I'm Carla Gonzalez. Until next time.